talk about how councils are criminalising landlords and how tenants are getting in on the Act too. So, landlord licensing and defence. We help landlords who get into trouble. Many landlords do, many genuine mistakes, many because they're not aware of things. Some get away with it, others don't. A little bit like motoring offences, but there are some landlords who just don't give a damn and they do break all the rules. No matter which one a landlord falls into, councils are ruthless at what they do, and they're criminalising landlords, and the tenants are getting in on that act with something called rent repayment orders. So there was a case this year between the London Borough of Waltham Forest and two landlords, and this was about the crime of an unlicensed HMO, and the HMO was occupied via an agent who had allowed them to bring in more people who were unrelated into the property. And Mohamed and Lahrie had thought that this was not their fault. They had a reasonable excuse and they didn't know. And they said that they weren't responsible. The judicial review found out otherwise, and the judicial review is an expensive thing to do. And the London Borough of Waltham Forest was successful in proving that it's a strict liability crime. So you're guilty, either you know you're guilty or not. Think of murder and manslaughter. It means if murder and manslaughter are two different crimes, one has intention, one doesn't, you would understand that manslaughter, you had no intention. Well, in a strict liability crime, for simplicity, you don't have to have what they call mens rea. You don't have to be consciously aware or premeditatedly decide to let your house out as an HMO. The fact that it becomes an HMO through what the tenant might do makes you guilty of the crime. So you should know who's in your property. This happens because subletting is happening everywhere, which leads me on to subletting and rent to rent. There was a case that went to the upper tribunal, and this was referred from the first tier tribunal because the landlord had done a rent to rent, and the company, the mean landlord in between, or the mezzanine landlord, as some people like to pronounce it, but it is pronounced mean, was not even aware the rent repayment order had been applied for by the tenants Jepson, Murphy and MacArthur against the senior landlord Rackerson. And the senior landlord was found to be responsible, and it's been referred back to the first tier tribunal for a decision. Interestingly, this happened in the London Borough of Camden, and Camden has a policy not to grant licenses to landlords who have less than a 5-year term. So interestingly, if you're doing rent to rent and you have a property and you apply for a license, it's likely to be refused, as they will find you not the most appropriate person to hold the license. And that is mainly because many rent-to-rent companies do not have assets, and the license term is generally 5 years. I have made communications with Camden. I'm waiting a response from them. So why do landlords get criminalised? It's most of the time is for licensing offences, and these are generally Section 72, which is HMO, and Section 95, which is selective licensing. And I'll be sharing a little bit later on which boroughs have which in London. The main thing is the consequences of licensing are that it could be putting people in danger. Many councils believe, but through licensing, they show and prove what needs to be done. Now, I could prove over and above many times that licensing doesn't always improve property, but the law is the law, and we must comply with the law the same way as I must comply with the 20-mile-an-hour speed limit that passes right by my home, rather than just continue to drive at 30 miles an hour. The law is the law. How are these dealt with? Generally with civil penalties. Sometimes it's prosecution, but for some it is severe as finding them not fit and proper. And the big one for licensing offences, which is where the tenants are getting in on the act as well now, is rent repayment orders. So please do listen and understand what I'm saying. And if you do need any assistance, I will leave my details at the end so that you can find out more. So enforcement. The areas of enforcement we are seeing most of at the moment is landlords with lodgers who have more than 2 lodgers are finding they are getting into trouble for not having done HMO management regulations, and sometimes they need a license. The other areas we're seeing is people where family culture where everyone is family. So in the country my wife is from, which is Mexico, family is everybody and family is everything. And in many, many cultures, family is everything. And when people come to visit from another country with the intention of maybe coming to join their family, which may not be connected by sexual or blood union, they're not really their family. And that is where HMOs are created. And this is a real problem. And we're seeing more and more of this. And sometimes the family does move into the house and there's some change in the family circumstances. Somebody leaves, they see themselves as responsible for the rent, and the tenant, unknowingly, to the law, they bring other people in order to just pay the rent. And you as a landlord, as I said earlier on, they're not finding out until it's too late, until the council's enforced that this is a mens rea situation and strict liability crime. Agents, landlords, and the rent-to-renters can all be liable depending on the local authority. And for rent repayment orders, I'm sorry to tell you, but the agents cannot be issued a rent repayment order, so it's only the landlord. So make sure you're using a proper accredited agent, because it's money for most councils, money. And it's getting a little bit like American lawsuits in that, they are just going after the money and they start as high as they can. I was talking with an enforcement officer last night, and an £185,000 of fines was issued. And yes, that will eventually, under some negotiation and mediation and the first tier tribunal, that will probably be brought down to a more reasonable and manageable figure. And we've seen one recently we've been working on that was 114, and we hope to have settled that with the tribunal following the real policies at around 35. But the biggest issues that we see are around room sizes, amenity standards, and fire protection. Many people, they don't protect the property correctly. They don't protect the escape route, the door locks. They've got the incorrect tenancies. They've tried to do evictions. That triggers things. And then you have serviced accommodation and HMO in London. A lot of people are getting that really wrong. So those issues are coming up both with planning, with licensing, etc. And then rent repayment order. The tenant, it says FFA. That's free for all. This has become the new PPI. There are no win for no fee firms out there doing whatever they can to big up these things. So what are the triggers? It's generally house activity, too many people coming and going, parking issues, bins overflowing, or most recently, especially through lockdown, there's been incidents with the police. And when the police come, they will report any house of multiple occupation to the council, whether or not it's licensed or not. Many of the councils are using intelligence, cross-referencing council tax, cross-referencing electoral roll, cross-referencing credit reference information if they can. And the other big one is benefit claims. When people go to claim housing benefit, etc., and they ask them some questions and they find out through the questions they're asking that it is a house in multiple occupation. But the other one, it says it there, it says a big trigger is door knocking. Councils have CEOs going out knocking on the doors. Now, that's not the chief executive officer, that's a council enforcement officer or a civil enforcement officer. As I predicted more than 2 years ago, the people that do the car parking and check you, giving tickets and people parking in the wrong places, their job will expand into doing other things. And we're seeing them now. There's civil enforcement officers going around checking dustbins, checking the number of people coming in and out of properties, etc. So what are the big misunderstandings? Well, the big misunderstandings for most landlords like yourselves is HMO, 2+3, 2 households and 3 occupants. That is an HMO. And at that point, HMO regulations apply, and that includes thumb turn locks, fire doors, protected fire escapes, and there'll be different regulations and different amenity standards depending on which council you're dealing with and at what time. The other misunderstanding is that you can talk to the council. You can talk to the council the same way about what you're doing right or wrong, the same way as you can talk to a policeman about committing murder or committing a crime. Once he finds out you're going to have an intention, he's probably going to do something about it. The council is not your friend. They are enforcement people. You go to them for advice, they may give you the wrong advice and then enforce against you, and there's really little you can do about it. There are 3 councils I've dealt with just in this year who, quite frankly, their behaviour has been completely unacceptable. But what we have done is we put them in their position where they need to answer for the mistakes they've made. Remember, under the Housing Act 2004, the only people there are any consequences for with punishment appears to be the landlord. There is the local government ombudsman, but as you'll find with most ombudsmen, they're really set up in favour of the people that you're actually going against. Most of the time, they're not worth the space or the waste of time. The other misunderstandings are most landlords have a lack of knowledge. And the biggest one I see is the resistance to pay for help. Many people, we have them call us and they are in masses of trouble and they think they're going to talk them their way out of it. So they rent a house to a family, the council has found out that the house is filled with people who shouldn't be living there because it's either been sublet or they've got a bunch of friends in and 10 and 12 people are there. There is no defence. There is no reasonable excuse in that situation. So you've got to do something about it. You've got to be absolutely sure who is in your house. Which brings me on to compliance. These are all the things that you've got to comply with. HHSRS, fire regulations, lay course, management regs, regular inspections, every month in an HMO. I know you might be thinking, well, that's too much on the quiet enjoyment. You need to check the common parts every single month, more regularly if you can, using your cleaners and people who do the alarm tests, etc. But you need to know who's in your property. And if you are not inspecting the rooms every 3 months, looking for things, obvious signs of extra people, you are going to be in some trouble. So there is enforcement. Again, many of you are getting licenses, HMO and selective licenses, and you're agreeing to the conditions in them. Those conditions are punishable under law. So you may not want to agree to them, so get them checked. You've got to have your EICRs, you've got to have your gas safety certificates, your PAT testing, your emergency lighting, your fire alarms. But the big thing with compliance is think about the intelligence that the councils have and all the people they're connecting with. Which brings me on to HMOs and planning. Many people ask questions about HMOs. HMO C4 is up to 6 occupants. It is 10 years old now. It was in October this year. 10 years old. C4 is included in the General Permitted Development Order. But if Article 4 is in place, councils can still insist, absolutely insist, on planning because that's part of it. And if it's more than 6 occupants, a 7 and above, planning is necessary for the change. There will be people who will argue that going from 6 to 7 isn't a significant change in use. But again, it's about if you want to fight it, how much money you're going to spend doing that, that is up to you. So what is Article 4? As I said, it removes the general permitted development rights. It restricts HMOs in certain areas. So around universities, you find a lot of this. It's usually a given geography within the local authority, but in some areas, it is a blanket in the council areas. We'll come on to that later. So what are the implications of Article 4? Planning permission is needed if 3 people share. Now, many of you don't know that. You might be working with an agent, they let it out to 3 people, and you're in breach of planning. And to be in breach of planning isn't a crime, but if a planning enforcement notice is given to you, then it does become a crime. So time needs to be taken for a planning application process. And remember, when you make a planning application, they will put notifications on lampposts in letters and tell all the neighbours, and they will enforce. Now, people often ask about licensing. I've been hearing about common parts licenses. There is no such thing. Okay. There are only 3 types of licenses. There's the mandatory, which applies to all HMOs of 5 occupants or more. There's the additional, applies to 2 out of the 33 London boroughs, and there's selective license, which applies to 11 out of the 33 London boroughs. So as we're talking about London, this is very much a London presentation. Licensing and management regulations. An HMO at 3 unrelated people, sometimes there's additional licensing. You need to understand the amenity standards, the HHSRS, the lay courts and the local council, and the management of HMO regulations 2006. You must go and look these up. So which areas will need additional and selective licensing? As it says there, HMO and additional HMO licensing comes under Part 2 of the Housing Act 2004. And 2/3 of the boroughs have that in London, and selective license comes under Part 3 of the Housing Act 2004, and that is in 1/3 of the London boroughs, but they're not all the same as the ones that are for additional licensing. So let me come on and show you about those. Very few people have gone to the trouble of understanding this. This is where Article 4 applies, and as you can see, it doesn't apply in Bromley, Camden, City of London and Hackney, nor Islington, Kensington, Chelsea, Kingston, Lambeth, Merton, Sutton, Richmond upon Thames, Wandsworth or Westminster, because they don't have a big HMO problem, I would suggest, in those areas. In Article 4 exists in Havering, but the only places where you can make an HMO without needing, what Article 4 doesn't, is where there are big, large detached houses. So now let's look at Article 4 and what the licensing is. And as you can see here, it's very important to understand that what each line is telling you. It tells you the embarking data. We've got Article 4, we've got mandatory licensing, digital licensing, and selective licensing. So literally anybody renting a property in the London Borough of Barking and Dagenham is going to need to have a license for their property, no matter what they're doing when they rent it out. And if you want to make it into an HMO, of course, you're going to need to get planning permission, unless you're buying or renting one that's already licensed. So there's more information there, so you can see all the others. So what is HHSRS? This is the Housing Health and Safety Rating System. This is based on probabilities across the 29 hazards and their harm and effect. And this is essentially part 1 of the Housing Act 2004. And it applies to all dwellings. This is the house you live in. This is the house you rent. This is the house that your mum and dad lives in, that they own. You have to comply with part 1 of the Housing Act 2004. That is not just for landlords, that's for everyone. Okay, what is LACORS? Most people don't know what that means. It's the Local Authority Coordinated Regulated Services. It's old, it's outdated, and it's really only guidance. If you want to understand the right thing when it comes to fire and fire alarms and smoke alarms and detectors, then you need to look at BS 5839 Part 6, 2019, because most council staff do not know how to interpret LACORS, let alone BS 5839-6, 2019, as well as you probably could. And if you're not sure, you can always talk to the local fire officer. And the local fire safety, the fire authority delegates the management and the enforcement most of the time to the council. So the council should refer to the fire authority if they are not sure or they need further guidance. And often they don't. Often they misadvise landlords without checking. And if you feel you're being misadvised, do call the local fire authority and ask them. The different fire authorities have different rulings, as do the councils. So I was asked to talk about council standards and best practices. There's different standards in councils for licensing and for planning and for building control. And most of the people that you're dealing with in the councils who you talk to are highly inexperienced. And they make many mistakes. So do not talk to the council and act without having whatever they've told you in writing. Absolutely, you must do each and every time. Now, enforcement. There is no court needed, and civil penalties are up to £30,000. The councils are the police, the judge, and the jury. So you must be sure, absolutely sure of what you are doing, because you are essentially guilty until proven innocent. Remember mens rea, remember strict liability. Well, you know, most of the council websites make no reference to these crimes that you are committing that you don't realise are crimes. Okay, a civil penalty is an alternative to prosecution, and as you can see, there are what the councils are doing for it. It's mainly licensing. It's not complying with the housing notice, which is normally an improvement notice. And mostly, and most of the time we see, it's about management regulation breaches. So, but what are they being fined for? Look at that. It's mainly around fire stuff, which most of them don't fully understand anyway. But look at these other things there. Right now, at this time of year, you're going to see lots of damp and mold, and you're going to see lots of poor or no heating in properties. Really, really important that you get that sorted, because if you don't, within 24 hours, they're going to call the council, and the council's going to come around and they're going to start doing enforcement. Even if they issue a small notice, most of them are charging £300 a time for a notice now. Okay, and there's more. Yes, representation. If you get to go to tribunal or to court, you will need representation. This is, as I was saying, there's a lot of people have reluctance when they receive a civil penalty notice to have somebody professionally go through that for them and check that the process has been followed properly, it's been dealt with properly. many civil penalty notices are wrong, and many of them are not being issued and followed due process. If you're summoned to court for housing offences, this is not good. You should get in touch with us because you will need really, really good representation. Some of you will have seen the case recently that we did where in the hearing that was just going to be a plea hearing, we fought in our team and we managed to get half of the allegations and the charges dropped at that hearing, and the rest are being dealt with now, and we hope that some of those will disappear, if not all of them, by the time the hearing comes up in March. But if you go to the tribunal, the three things that you're going to have generally at the first tier tribunal, mainly licensing offences, so you're fighting a civil penalty notice, or you're fighting conditions of the license, which is often room sizes, or you can't have the number of people that you want, or you can't have it the way you want it, because you're going against really aspirational standards that councils have set. Improvement notices is another. Quite often people want to challenge a tribunal notice because quite often the councils require something more than is necessary. So I had a situation in a house recently where they wanted a new FD30S, that's a fire door smoke sealed door set put together, so that includes the frame, when actually all that needed to happen was change the intermittent strip to a intermittent strip with cold smoke seal. And the other thing at the tribunal is rent repayment orders, and this is where the tenants are really in on the act. They really, really are, and they are going after landlords, and there have been some rulings recently which, you know, I've been very, very successful in rent repayment orders and managed to get them reduced massively. But we're seeing more and more cases and more rulings coming and decisions that are showing that you're not going to get them reduced as much as you did in the past. And you can't do these things on your own. Once you get to a certain point, even the tribunal will say to you, go and seek professional help from companies like Landlord Licensing and Events. So let me talk about representation. We do representation because if you're trying to fight the council, one, they're doing this every single day, so they're practiced at it. So it's like going after, it's like trying to race against the Usain Bolt. Yeah, Usain Bolt knows what he's doing. He runs and sprints, knows what he's doing. I wouldn't even think I could run like him, so I wouldn't try and compete with him. Whereas many people don't want representation; they try and fight the council. The council will outsmart you with their knowledge and their endless funds of money they have. Then there's the tenants. The tenants with the rent repayment orders, the no win, no fee. Well, they're conditional fee arrangement lawyers are doing no win, no fee. This is the new PPI for them. And once they start, they don't stop. We have heard of a case this week, which we are working with somebody. It's going to the upper tribunal because the tenants aren't satisfied with getting a rent repayment order because the landlady didn't have a license. They're also going after her for other things such as illegal eviction. They're saying, well, we're not satisfied to get our rent back once. They want it back 3 times. 3 times the amount, because they're saying we want it for each offence. And then there are charities, and I talk about charities like Shelter, Justice for Tenants, and Flat Justice. These are just stoking these intense fires of these tenants, and intensely saying that you're going to get loads of money, you're going to get loads of money, and they are destroying landlords and destroying their mental health. So many people ask me, well, what are the councils like? So my experience, and this next couple of slides are not to be shared. This is information that we have gathered from the work that we've been doing in this industry. Okay, this is the councils and their approaches. Okay, London Borough Tower Hamlets, you've got to be very careful about the leases with THN. Burnley, they're very strong on their selective licensing. Northampton, big fines. Manchester, they make lots of errors. Harlow is going on about their covenants. Wirral are very heavy-handed. London Borough of Barking and Dagenham, they're very, very hard. As you see, they've got all the scope. Okay, Kingston, it depends on who you deal with. Croydon, they seem a little bit confused about what they're doing most of the time. Liverpool, they will partner with you. Brent, they're fair, but they're also strong when you're wrong. Camden, they're very, very hard and quite often get things wrong. So you need to know what's wrong because sometimes you don't. Winchester, they're hard and right. Newham, they're fierce and hard. Coventry, well, they're absolutely ridiculous. They will try and find you not fit and proper and revoke all your licenses, although they've been kicked into touch recently from some of the work that we've done and the tribunal has done. Southwark, they're quite harsh. Westminster, they can be okay. And places like Spelthorne, out near Staines, they're pretty light on what they do. So that's just some of the places that we dealt with, and some of the experiences we've had. That doesn't mean it's going to be the same all the time. There's one in the Northwest we're currently dealing with. We're dealing with one officer who's breaking all the rules, and dealing with another officer who is completely compliant and really helpful, because they want to solve a problem. So you can't absolutely be sure. But there are loads and loads of pieces of legislation, 150 new laws and pieces of regulation in the last 10 years. That's more than one every week. So be very, very careful. Another area we're seeing a lot of issues with are deposit protection and your cash flow. So if you put it in a custodial scheme, the TPS has the money. If you put it in an insured scheme, you have the money. But if you're doing first month and last month, you'll have the money, but you will be up for a possible 3 times claim for up to 6 years they have to claim that. So please, if you've been doing first month and last month, I would suggest the only safest way to get everything sorted is to get them into a new tenancy agreement so that they can have their deposit protected properly. They could still, for the up to 6 years, claim on the other one, but seek advice on that. We can help you with that. So rent repayment orders and civil penalty notices. Management regulations are the ones we see the biggest enforcement. It can be as simple as not putting a sign in the HMO stating the manager's name, address and contact details as is required under the management regulations. Licensing, quite often, who is the responsible person? Remember I spoke earlier about Camden and about the case where the mean landlord or mezzanine landlord, as some of you call them, it's pronounced mean, mesne from mezzanine, so in the middle, as you understand. So who is responsible? And there's the Protection from Eviction Act 1977, eviction or harassment. So if you harass your tenants or try to suggest that they leave and they have a right to tenure, and you might can give them any agreement you want, but if it's deemed an AST in the court, you're likely to have a rent repayment order. Now, the bit that doesn't seem fair is the letting agents who may have allowed these tenancies to be created in your name and acting on your behalf, they cannot get the rent repayment orders. So it's really important that you regularize your business, you comply, and you consult with people who can help you, right? Rent repayment orders, I am going to keep going on about these. These are the tenants' weapons of mass destruction. They are destroying landlords currently. The agents can't get them. So as I said in the last slide, regularize, comply, and consult. Because landlord licensing and defense, as it says there, we cut to the chase, we get things sorted. As you can tell, I'm excited about this business. I'm excited about helping people. I'm excited about putting those that are abusing the system, those in power, putting them in the place they need to be. There are vicious people, as it says there, enforcing the Housing Act. So they're doing it with angst. They are getting on a power craze. Some of them are abusing their position in power in public office. That will also have to be dealt with. So get in touch with the council. Get in touch with us if the council gets in touch with you, but do not get in touch with the council. We will work for you like no other. If you don't believe me, get in touch and you will find out. But it is defence through compliance, not defence through committing a crime and then hoping to get off. There's my details. If you'd like to scan, you can see there's a QR code there. You can connect with me on LinkedIn. I would love to be able to help you if you need my help. If you want simple advice, generally we should be able to help you too. Do get in touch. And we do offer a 20-minute free consultation. And if you'd like that, do contact me through the group and I will be able to assist you. I thank you very much for the time. Thank you. And if you've got any questions, please let me know. That's what I'm here for.